Law of Treaty in international law. Definition is given in Article 2, 1a of Vienna Convention on Law of Treaties, 1969. An international treaty is an agreement between two or more states whereby they establish or seek to establish their relations governed by international law. The object of the treaty is to impose binding obligations on the states who are parties to it. Legal reference in this case is the Vienna Convention on Law of Treaties, VCLT, 1969. The important maxims you come across while studying the Law of Treaties are as follows. First is, pacta sunt servanda. It means states are bound in good faith to fulfill obligations assumed by them. Second is, rebus sic stantibus. It means if the material circumstances under which a treaty is concluded change, then it becomes the basis of change or termination of the treaty. Third is, eucogans. It means a treaty is valid if at the time of its conclusion it conflicts with a peremptory norm of general international law. McNair classified treaties in three categories. First, treaties having the character of conveyances. Second, treaty contracts. And third are, lawmaking treaties. When it comes to the competency of parties entering into a treaty, generally, only states which fulfill the requirement of statehood and international organizations can enter into a treaty. Moreover, free consent of both parties is necessary to enter into a treaty. International treaties made under coercion are considered binding until the object is valid. For example, treaties entered into after the First and Second World Wars. Formation of treaties is an extensive process. A treaty is formed if all these steps are followed accordingly. Number 1. Accreditation of persons on behalf of contracting parties. States authorize representatives for negotiation on their behalf. Number 2. Negotiation and adoption, VCLT, Article 9. After matters are settled through negotiations, a treaty is adopted. Number 3. Signatures, VCLT, Article 10. Authorized representatives sign treaties on behalf of their states. The treaty does not become binding on this stage. Number 4. Ratification, VCLT, Article 18. Heads of the states or governments conform to the provisions by approving the signatures of their representatives. Once ratified, the treaty becomes binding. Number 5. Accession and adhesion. Practice shows that states that have not signed the treaties earlier may also accept it later on or adhere to it. Number 6. Entry into force, VLCT, Article 24. Parties of a treaty are bound by that treaty. Pacta tertius nec nocent nec prosent is a Latin usage of words which means that a treaty binds the parties and only the parties. Number 7. Registration and publication, Article 102 of the Union Charter. It is necessary to register and publish the contents of a treaty so that states may not enter into secret agreements. Number 8. Application and enforcement. After all these steps are followed, the contents of the treaty are applied and enforced in its true spirit. When it comes to the interpretation of treaties, a treaty is interpreted on numerous levels, such as grammatical interpretation, object and context of a treaty, reasonable and consistent, principle of effectiveness, recourse to extrinsic material. Termination of treaties happens in the following ways. Legal reference in this case includes Articles 54 to 72 of the Vienna Convention on the Law of Treaties. 1. Extinction of either party to a bilateral treaty. The extinction of either party to a bilateral treaty may terminate the treaty. 2. Outbreak of war. The outbreak of war ends treaties with exceptions as follows. General relations and political ends. Fixation of boundaries remains unaffected. Relating rules of war remain in force. Relating to health, service, and protection of industry remain suspended but do not end. An express provision may end a treaty. 3. Material breach of bilateral treaty. A material breach of bilateral treaties by any one party entitled the other to terminate it. 4. Impossibility of performance. As stated in Article 61 of VCLT, 1969, the impossibility of performance leads to the termination of the treaty. 5. Rebus sextantibus. Rebus sextantibus is a clause in international conventions, international agreements or treaties, that provides for the unenforceability of a treaty due to fundamentally changed circumstances, for example, war or dispute. This doctrine is one of the oldest norms of customary international law. 6. Expiration of fixed term. The expiration of a fixed term automatically terminates the treaty. 7. Successive denunciation. As stated in Article 55 of VLCT, 1969, successive denunciation shows a unilateral act by which a party seeks to terminate its participation in a treaty. 8. Cogents. An existing treaty becomes void and terminates if it conflicts with a new peremptory norm of general international law, cogents, that emerges subsequent to the conclusion of the treaty.